G'day there guys, it's your Aussie Hubby Markee, back at it again with another episode of r/Legal Advice. Now I know you guys love legal advice and I have no clue about law, so let's start this journey. I hope you guys enjoy it. Smash that like button, chuck a prawn on the barbie, and let's get to it. Posted by user 3-Wheel Throwaway, titled, Girlfriend received a DUI in a car that only had 3 wheels. This is in West Virginia. Throwaway because she knows my regular account and wouldn't want anyone else to know about this. My girlfriend and I went out for dinner, then bar trivia and drinking. I only had a few drinks the whole evening, but she had 5 to 6 mixed drinks and was very drunk. When it was last call, I decided to drive her to her house in her car, then Uber back to my car and go home myself since I had work the next day. I put her in the passenger seat of her car and started driving to her house, but on the way, I hit an awful pothole and busted a tire. I pulled over in a parking lot and started to change the tire, but left the keys in the ignition so she would be warm since it was pretty chilly out. I jacked the car up and was proceeding to change the tire when a police car pulled into the parking lot, and I thought he was going to help me out, but instead he asked me if I was drunk. I told him I wasn't and explained I was taking my girlfriend home since she had been drinking. I took a voluntary field test and breathalyzer and blew under the limit. He then looked into the car and saw my girlfriend half asleep in the passenger seat and asked her if she was drunk, and she said she was just sleepy. He then made her get out of the car and do a field sobriety test, which she failed, and then the breathalyzer, where she blew a .10, legal limit in the state is .08. He then placed her under arrest because the keys were in the ignition and she was the only person in the car and intoxicated. Please note that at this time, I had not finished changing the tire, so there were only 3 wheels in the car at the time. He took her to the city station, and after I fixed the tire, I went down and bailed her out. My question now is if it was actually a DUI. It seems very silly to me that she was charged since she was buckled up in the passenger seat, and there was only 3 wheels on the car at the time. We don't want to go through the first-time offenders program if possible, since it requires a plea and she is afraid it could affect her graduate work at university. Thank you. You should get an attorney. If you're being 100% honest, don't accept any plea deal either. This sort of police behavior falls directly under revenue generation. I know it sounds ridiculous. I couldn't believe it myself. The thing is, this is a large university town, for the state at least, and all my encounters with police before then have been run-of-the-mill. We've narrowed down to a few attorneys at this point, and I'm checking options before we call Monday or Tuesday. As long as you are actually the one driving, then this case will most likely be thrown out. While the officer can charge someone for being in a vehicle with the keys in it and running, in this case, you are obviously changing a flat, and she did not have control of said vehicle that was immovable at the time. You might need an attorney, but it will save you time and money in the long run. What's critical is that your emotions not get involved. You're 100% in the right here, and a vaguely competent lawyer will get this discharged. That's a bad cop. A good DUI lawyer will take care of this. Just needs to be presented to a judge. You admitted you were the driver, you blew under the limit, your girlfriend was buckled up and passed out in the seat. There is nothing illegal about driving drunk people home. In some areas, you can be charged with a DUI if you're in a car with the keys in the ignition, even if it is not moving. So there may have been legal grounds for the arrest. However, this does seem like an abuse of power given the circumstances. So get a lawyer, and I'd recommend one that specializes in something like DUIs or criminal defense. Just curious if you would know the answer to this. Now that push to start is becoming the norm, and having the key in the ignition is impossible in some cars, could someone with keyless start be charged for having just their key in their pocket and be seated in the driver's seat? In New York, having the keys in your pocket is viewed as intent to drive, and the driver may be charged. It's a good answer, thank you. I think the vehicle missing a wheel and the literally driver of the vehicle being outside of the car makes the whole ability to drive while drunk part of the law pretty irrelevant. Nothing in my comment was disagreeing with you. I was simply pointing out that a lawyer is necessary because it's not like they can bring up the details themselves in court and get it thrown out. Cops should exercise common sense, absolutely. This was absolutely an overreach of power. But it's not simple because the law may be on the side of the officer unless there is a lawyer to argue for them. Also, as someone has pointed out, you can drive some distance on the rim of a car, so simply missing a tire isn't going to stop a drunk person from driving, and that's the sort of defense a lawyer is necessary to argue. Unless I'm misunderstanding OP, there wasn't even a rim and it was on a jack. If it wasn't on a rim in that state, the body would be riding on the ground. Definitely not a drivable state. Mr. Science Sold, you have definitely not seen some outrageous driving videos then, buddy. Barmer Breeze 505 says, this is known as an opportunity DOI. It typically requires establishing intent to drive while under the influence of drugs or alcohol. In the case of people with a history of DUIs, intent is as simple as having the keys and being within 25 feet of the vehicle. In less defined cases, it generally involves having the keys in the ignition. However, given that the car was not in a drivable condition, there was no opportunity, and thus should be lawful. This sounds like an egregious reach for meeting in parameters. The grounds for arrest would only be warranted if the car was drivable. Even still, you driving her home is an example of you doing the right thing. Get a good attorney and hope that the cop accurately wrote his report. It should get thrown out, but the legal system is far from perfect, and the sad truth is that your girlfriend might have a DUI on her record over this nonsense. I goofed up, I thought there was an update for this, I'm sorry. We're moving on to a post with an update. By user ErgDrive, titled, Kid in school playground across the street threw a rock through my window. Is the school liable? This is in Illinois. So I live across the street from a private Catholic school. One of the students in the after-school program threw a rock into the parking lot where my car was parked, breaking a window. The falling glass scraped paint off the door directly under the window. The director of the after-school program left a signed note admitting that a student threw the rock that broke the window. Now they're trying to get me to deal directly with the parent of the student, who don't have the money and have told me to take them to court. I have a text message from the director of the after-school program stating that the parents have agreed to pay for the window, but that they have doubts about the resulting scratch. I have pictures from the night of the incident showing that it is fresh damage. Rather than trying to get the money out of the parents, which is all but certain to be a drawn-out legal process of garnishments, etc., is the school not the liable party here, and should I just file the small claims case against it? You would have to prove that the school was negligent in their care of the children and/or policies of the after-school program, which directly caused your damages. Would lack of appropriate supervision not be sufficient to demonstrate negligence? It would be very difficult proving a lack of supervision when the supervisor posted the note on the window. You could have a student standing next to a supervisor and throw a rock, and then run to get in line to come back inside. Things to think about. PE classes will have 40+ students and only one teacher. Using that formula, it would be hard to say that they would be negligent. Does the school have cameras outside? You could see if they have a copy if they do. You could argue that mitigates a claim of negligence against the teacher, but not against the school that determined that one teacher is sufficient to supervise 40+ students during an outside PE class. The State Board of Education allows class sizes of 40+, that's why they can do that. You then would need to go after them. OP said it was a private school. Missed that? Thanks. If the private school uses the guideline given by the State Board, would that cover them? They might be able to argue it as a professional standard, but I wouldn't expect that to work where I am. I don't know about it. This is why you have insurance. Just tell your insurer and they'll work out who it's worth suing. The lowest deductible I have had from homeowners is $1,000, which is probably more than the cost of the replacement. It sounds like the damage was to his car. His car insurance, comprehensive coverage, would be applicable. Also, you can ask if the parents have renters or homeowners insurance. Their liability coverage would pay for the damages. Liability coverage does not have a deductible for the policy owner. The parents wouldn't have to pay, but may have their rates go up. One of the parents does not have homeowners insurance, and it's the same parent who has told me that they don't have the money to pay for the repair and to take them to court. I'll go that route if I have to, but I'm trying to avoid having to squeeze blood from a rock. OP also says, between my deductible being higher than the cost of the repair and my already high premiums by virtue of being a newly insured young male driver, I'd rather not file a claim with my insurer for something like this. Not a lawyer, but a parent who manages after-school programs for our elementary school. Because these programs take place outside of school hours, generally by private companies or non-profits, we require them to carry their own insurance before they're allowed to conduct their program on our grounds. Not sure if your situation is similar, but it might be worth finding out if their after-school program is run by a third party whose insurance could certainly be easier to deal with than the school's. Not a lawyer. When my wife's car was hit while it was parked, our insurer told us it was our property damage, since her car was parked at the time of driving. As a result, the other person was responsible 100%, didn't use her deductible, and didn't change her premiums. I wonder if the same rule applies here. My only hang-up is that it wasn't another car that damaged your parked car, but a kid with a rock. Update. Kid in school playground across the street threw a rock through my window. Is the school liable in Illinois? As an update to this thread for anyone interested or who finds themselves in a similar situation, the school ended up paying for all the repairs to my vehicle. According to my insurance agent, the magic words are custody, care, and control. The school was acting as a guardian of the boy, therefore it was fully liable for the damage he caused. Posted by user SayWhat63, titled, I really think that making out my will is going to kill me. My folks left me their house and property in their wills. Now a relative is pressing me to make out my will, even going so far as to offer to take me to a lawyer. I don't drive. Problem 1. By law, I need 2 witnesses. I don't want my relative to be one of them, but I also don't want to be upset or offend her by bringing along 2 friends of mine when she does take me. In the event that my friends are willing to help me, should I ask them if they're willing to bring me to a lawyer instead? Problem 2. In my parents' wills, it was stipulated that my husband will not inherit the house and property, etc. So my question is, do I have to stick by my parents' edicts, or can I, as the legal, deed-carrying owner of the house, ignore that part of my parents' wills and have his name put on the deed, thereby making him the first beneficiary? I tried to Google the answer, but I'm not very tech-savvy and might have looked right at the answer without realizing it. Any advice would be appreciated. A good estate lawyer, one you ultimately choose, not one chosen for you, will discuss different options for estate planning and give you time to think about which one is the best choice for you. If you think the relatives who's pressuring you is money hungry, watch your back around them. Ask about a revocable living trust instead of a will. Wills can be contested, trusts are much harder, if not impossible, to challenge. Take an Uber to the lawyer's office and they will provide the witnesses. You shouldn't involve other people in your will prep because family members lose their minds when money is involved. Your lawyer will handle all of the questions, that's their job, and they will help you. A witness need not be someone you know, and especially if they're relevant to the document being signed, they cannot legally be a witness, as to ensure no coercion takes place. Whatever I sign, I prefer to have people who barely know me witness it. Maybe one friend unrelated to the topic, and another provided by the lawyer, but that's it. Typically, having a will drawn up involves at least 2 appointments. One where you discuss what your assets are and what you'd like to do with them, and a second where you review everything and sign it. In my area, most lawyers have paralegals serve as the witnesses, so you don't have to bring anyone. If you can leave your inherited property to your husband or make him a joint owner is going to depend on where you live and exactly what your parents did with their estate. So bring your documents to the first meeting and discuss it with the lawyer. If your relative is making you uncomfortable, find your own estate lawyer and ride. But it sounds like you inherited enough that it's best to have your own will. Tofurkey Freak Mitten says, I work for a law firm that prepares wills and estate planning documents. I do other work, mostly unrelated to that, but when we do will signings, the EP paralegal and I are the witnesses, not whoever shows up with the clients. We have done remote signings at hospitals, hospices, and rehab centers, and we almost always supply both witnesses, unless there is a reason we can't or aren't allowed to. I think you are worrying way too much about this. Have you considered a remote consultation? Plenty of attorneys are doing them under the current circumstances. My husband practiced in another state of Texas before we moved where we are, and there are special rules in place to permit video notaries for will sign-ups there. So it is also possible to do that remotely in a few places, I imagine. Edit: I don't know the relation of that person or whether they expect to be a beneficiary in your will, but if so, I don't think they would be permitted to witness anyway. 1. Not a legal matter, but there is no harm in having your friends take you, if that is what you are concerned about, nor is there any need for a witness to be a relative. So if you're more comfortable with them driving you, go for it. 2. More complicated. Wills can restrict future action with what is willed, but only to an extent. Ask the lawyer when you get there. They should be able to answer. You can also have the will include contingencies, i.e. a secondary beneficiary in case the primary one can't collect for whatever reason. That would put the house problem in the hands of other people in the future, if it ever becomes relevant at all. And OP says, update. I'd like to thank everyone for your advice. Some folks have asked where I live. I'm writing from Connecticut. You have all given me not only great advice, but peace of mind as well. And for that, I thank you. I'm going to start making calls on Monday. And I think that's a really good ending to that one. That's really wholesome. Good on them for finding the information they needed. Posted by user Cloppy78. Titled, California. We are a small indie porn company. Former model wants her videos removed, unwilling to buy the copyright. Sends threatening messages. She worked for us between 2009 and 2012. She has 17 videos on our website, although we have recorded 20 and plan to release the other 3 in the future. This is more or less 10% of all videos that we have. She first came to us earlier this year and asked what the process is to have her videos removed. She's getting married and her husband is not comfortable with these videos of her being online. We have quoted her the price of $25,000 per video to purchase the copyright to the contents for the 14 of her videos. 3 of her videos are very popular among our members, and we have quoted $100,000 per video for those. We also quoted $20,000 for the unreleased videos, so overall it was $710,000. We gave her a discount and called it $700,000. Also, the contract would allow us to continue using the material for a further 12 months. This is to give us time to produce replacement content. This is more than a fair offer in the industry. She wouldn't be getting anything close to this offer from a big studio. She chose not to take our offer. She offered to pay $100,000 for the entire thing to be removed immediately, and we declined. She has, however, been sending us letters threatening legal action if we do not accept her $100,000 offer, saying we are violating the good faith and fair dealing covenant by not accepting her offer, and she will be taking us to court. The letters are not from a lawyer. Do we have anything to worry about? As long as you have a model release signed by her, you are most likely fine legally. With that said, she can still make your life difficult if she gets a lawyer to sue you. And of course, if this case gets attention, it will hamper your ability to recruit future models. Have you considered working out a payment plan with her or something along those lines? The flip side is the Streisand effect if she does sue. How would her future husband feel about that? I would think that going public would ironically increase the value of the videos. Did you see that girl in the news on that porn site? Like, just this post is increasing the value. Ah yes, the anonymous post with such critical details such as indie porn company, girl, and California. Until I read this thread, I didn't know that it was a thing. As someone who's sick of regular mainstream stuff, I'm a bit intrigued and may do a little sleuthing around the internet for this newfangled indie stuff. What the hell? OP also says, I didn't mention a payment plan, but mentioned to her that she can buy them one by one if the entire fee is too much, which will be similar to a payment plan. Until you are served, it is hot air. If you are served, don't ignore it. Now would be a very good time to get an attorney on retainer. You should have one anyway in your line of work. Provide the attorney with copies of all correspondence, contracts, etc., plus anything you can find to demonstrate the fair market value of the content. Consider having the attorney draft a letter to her demanding all correspondence be directed to the law office. Knowing that you are prepared to make a fight of it may be enough for her to back down. If you have $710,000 in assets at stake, you can afford a consultation with a real-life, in-person lawyer. Do so. Exactly. I find it troubling that a company does not have a lawyer. We were thinking we'll get a lawyer when she gets one if we are sued. But $700,000 isn't at stake because she won't pay for them. We're just hoping she would disappear without causing problems. In assets was the crucial word. Fair enough. The best defense is a good offense. Get ahead of the storm by preparing yourself legally. Act, don't react. Not a lawyer, but a player in the industry. Go get an industry lawyer's advice on this situation. Technically, if your model release is solid, the performer can pound sand, but it doesn't mean she won't become the biggest pain in the ass you've dealt with or start threatening affiliates if you have a program. They seem to love this, and I'm constantly forwarding mails to my AF reps to send up their pipeline. Are these all puns? These are really bad puns. Go to one of the industry forums and ask for a lawyer's recommendations if you don't know industry lawyers. Yeah, thanks. I think it's about time we start a working relationship with a lawyer. We had one who solved a few issues in the past, but that person has retired and we haven't had issues lately. I think it's the best way to go. Until she decides to actually file a suit, it's all threats. But when you start factoring the time and effort to deal with the crazy, that adds up just as well. The other thing you might want to bring up with whomever you go with is her spreading rumors about you guys and damaging your reputation. I'm sure you're just as aware as I am how much they love to spread damaging rumors. And the best comment in this thread by Sully618, D. Now on to the update. There is a lot to discuss. We did a little research and turned out her stories about getting married and her husband wanting the videos to get taken down were lies. She, in fact, is starting a membership program on her own website and wanted to use that excuse to get our videos at reduced prices, to post them later to her own website. Wonder if it's OnlyFans, who would have thought? She wanted to use the exclusivity to get some of our paid members and have a larger library at launch. Once she realized that we know of her plan, she offered to pay the full $700,000. However, we declined since we have no interest in allowing her to use our videos to compete with us. She even offered to pay $1 million if we agreed to take down the videos immediately upon the sale. We, of course, declined and informed her that we are no longer willing to discuss terms about selling our copyright. One other small studio that she has worked in the past with had already fallen for her lies and sold her the videos at non-competing prices. We're happy we didn't. We learned a new lesson. People lie in business to get better deals. Love that. Posted by user Doubts Within. Titled, I'm a pedestrian who waved in an SUV in a narrow gap and he got into an accident and he's threatening to sue me. This happened a few days ago. I live in Philly, and I was walking along a busy street, and I see this SUV at a one-way narrow street waiting to move forward at a green light. There is a small car ahead of him that's turning right. The SUV wasn't moving past the car because he thought he didn't have enough room. I saw that he did, and I just gave him a thumbs up that he can go. He ended up hitting the other car. He was trying to avoid the curb, I guess, and turned at the last second. They got into a bit of an argument and shared info and decided to call the police to make a claim, I think. I didn't really listen, but the other guy in the small car asked me to hang back and provide a witness in case he needed it since I saw the whole thing. They both shared each other's insurance and ID. The SUV guy asked me for my ID for witness too for his insurance claim. Soon after, he took a picture of my ID on his phone. He said I was the reason he moved and that he will have to make a claim against me. He is threatening to sue me and said that he would rather just send me the damage bill of both the cars. I felt bad because I gave him the thumbs up that there was room, but he did turn at the last second. The other guy was also annoyed that I shouldn't have told him to go. He called and left with a VM that I needed to act soon because if he makes a claim in court, it would lead to a lot of legal fees for both of us or something. He said that if I agree to pay, I can just pay half the damages. I'm worried that it's going to be a huge amount and I don't want to go to court. If it goes to court, will I have my credit ruined? Sorry, I don't know too much legal stuff. Edit. Now he is saying that my future will be screwed and my credit score is going to be messed up, and that there is a possibility that I may be criminally convicted. I'm an immigrant here on a visa, and I'm worried that it's going to affect me. Edit 2. Hey guys, thank you so much for your support. This has been really helpful. However, I am getting conflicting advice here. Some are saying that the other person, the SUV guy, has a case, and it seems like there have been cases similar to this. Some people are telling me that I am absolutely guilty and should have everything taken from me. Also, I'm not sure who Ayn Rand, legal author, is, and how this affects me. I spoke with a legal hotline service, and they said that they are not sure of the laws, but I need to go get a notarized letter from the SUV guy saying that I won't be sued if I choose to pay. I'm honestly super scared and stressed that my immigration status will be affected, like the guy said. Should I be contacting immigration lawyer too? Sounds like he's bluffing you into paying for damage that you were not responsible for and doing a pretty good job at it. As a driver, he needs to use his own judgment and not substitute it for the judgment of some random stranger walking down the street. My guess is he's going to put in a claim on his insurance and put the money you give him in his pocket. I doubt he will sue you. If he does, you need to answer. If he does sue, I doubt he will win. Until you receive the summons I doubt you will get, you can ignore him. This makes a lot more sense when you put it that way. Everything happened so fast. He was a big guy, for you, and was really intimidating, and I just gave him my info without thinking too much. If I do get a summons, will my credit score and stuff be affected? He said outstanding things like that will really mess up my future. Nope, your credit score has nothing to do with the summons. Also, even if you get a summons, that doesn't mean that you will lose. He's just looking for money. Just ignore him 100%, unless you do get a legal summons, then make sure you show up. But until then, don't respond to any calls, texts, and emails. Edit. Also, if you do get a summons, it will most likely be for small claims court. You do not need a lawyer for small claims, and as other posters said, he will be laughed out of court. Seconded. Because if you don't show up, you might just immediately lose the case default, regardless of whether you were actually responsible. If he was able to intimidate you once, he'll be able to do it again if you talk to him. If you speak to him, he's going to say all sorts of things that you won't know if they're true or not, and it will cause you a lot of confusion and conflict, and you will do/say more things that will make the situation worse for you. You can't trust anything he says. He is trying to manipulate you into getting money. Block his number, research a couple of lawyers to choose from in case you need them. Also, make sure to save all texts he sends and record any calls that he has with you. It sounds like this could count as borderline harassment at this point, which would negatively impact his credibility if he was dumb enough to try to sue you. Honestly, ignore him. If you actually are sued, speak with an attorney and respond, and ultimately, he is responsible for his own vehicle. He wrecked this vehicle, not you. He's trying to intimidate you because he doesn't want to accept responsibility. Just because someone waves you in doesn't mean they checked the right-of-way is clear for you. A lesson I learned when someone waved me in and I got hit and was responsible for violating the lane's right-of-way. This is practically the textbook example of hearsay as well. I must have heard the "someone waved me into an intersection when I couldn't see the light and it was red" example dozens of times in evidence. I noticed that you were seizing on and responding to the worst case scenario posts on here. Don't ignore the other, very good positive advice given to you. The odds of this person actually suing you are astronomically low. The odds of him successfully suing you are astronomically lower. The odds of him convincing law enforcement to press criminal charges against you are 0. This is a civil matter at best. Finally, in the incredibly unlikely scenario that you are sued, simply call your auto insurance carrier and let them know. Non-legal advice: cease all conduct with this person, do not answer your phone or respond to the letters. If he comes to your home, call 911. Update: I'm a pedestrian who waved in an SUV in a narrow gap, and he got into an accident and he's threatening to sue me. Hey guys, I got into a bit of a situation a few days ago, and I frantically posted about it here yesterday when the other guy contacted me multiple times, threatening to sue me. It was referenced here. I spoke with an advocate in Philadelphia, as well as a lawyer, and a few other people in the legal profession. They have all told me to relax and that a simple thumbs up will do nothing in the courts, and will not affect me in any criminal way, credit score, or immigration status being challenged. The lawyer even said that he'll draft a letter for me on my behalf for free and mail it to that guy to stop contacting me. He even suggested that he'll help me out for free if it goes to court. That's how confident he was that it won't go to court. I don't know if I'm allowed to give him a shout out. I took a few pictures of the intersection and showed it to the lawyer, which I didn't think helped, but the basic gist is that a thumbs up can mean anything, and the burden of proof is on the other guy, not me. He said that I wasn't actively directing traffic, but simply chose to let him know that he was good and has room, and it's up to him to make the final judgment. Personally, many others in the city have done for me when I was parallel parking, and I assumed it was normal here. The big lesson here is that never interfere with a motorist. Despite how aggressive that SUV guy acted, I still feel guilty since 2 people's days were ruined because of my interference. I want to help out, but strongly advised that by people that I spoke with not to, so I won't. Heck, there was even a Redditor who messaged me and offered to pay my legal fees if it came to that. The gesture itself is flipping amazing. Another Redditor offered to meet up with me and act as a friend, since I don't know anyone in Philly, if I chose to speak with the SUV guy, which he suggested not to. And another lawyer, Immigration and Injury on Reddit, that lives in Philly, offered to speak with me. I don't know if I can give them all a shout out either though. The point I want to make with this update is that this is a great effing subreddit with really genuine people that care. Tons of people took their time to personal message me since the thread got locked to tell me that I will be fine and that they will speak with me if I need to speak with someone. Also, Philly is a damn great city, and by no means was I trying to show it in a bad light. Messages from the internet who live here have been pouring in offering to help me out if I need it. I am simply going to stop communicating with this guy. Alright guys, that's all for today's episode. I hope you enjoyed it. If you did, be sure to tell me what you thought about it down in the comments down below. If you're new to the channel also, don't forget to subscribe. It would really help out with my channel growth. And also, a huge shout out to my channel patrons and members. I just love you guys and thank you for supporting me on this journey. If you guys are new to the channel and you'd like to support me, links are down below for the Patreon, or you can click the join button next to subscribe if you'd like to become a channel member. Alright guys, that's all for today's episode. I hope you enjoyed it. I hope you have a good day, night, sleep, whatever you're up to, and I'll see you in the next episode. Bye.